Hi everybody, welcome back. Today we are going to start our discussion of the federal conspiracy statute. As the reading indicates, this is a very popular statute in white-collar cases. It's even been called the darling of the prosecutor's nursery. In the vast majority of white-collar prosecutions that we see that involve more than one person anyway, we will see a conspiracy charge. And conspiracy charges are used for a variety of reasons, and by the prosecutors, that is tactical reasons. And I want to talk about those briefly right now before we start on the nature of the conspiracy crime and why we have a conspiracy crime at all. So first, though, let's talk about those strategic reasons that prosecutors use conspiracy charges. Now, these reasons are laid out in your reading, but I think they're worth taking a moment to look at as part of this lecture so we can understand why these charges are brought so often. First of all, conspiracy is what's known as an inchoate offense. That is, it's a crime that is complete and, in fact, chargeable before the object of the crime, in this case, whatever the underlying federal violation is complete. Okay, so you've got a conspiracy, a completed conspiracy, before there's any harm actually done in the real world, which means, among other things, it's easier for prosecutors to prove a case sometimes, because it sometimes may be difficult to prove that the defendants actually completed their crime, or maybe in fact they didn't actually complete their crime. But if you can prove that they agreed to do so, you can pin a conviction on them in cases that are appropriate. Secondly, by charging a conspiracy, when there's a white-collar case involving multiple defendants, if you charge a conspiracy, it's easier to try them all as part of a single case. So defense lawyers have an interest in trying to sever their clients' cases from the cases of other defendants, in particular because if you have a client who is, let's say, a smaller fish in the conspiracy, or a client where there's less evidence about their involvement than there is evidence about other defendants, then you want your client to be tried on their own, because the jury may be sympathetic to them. The jury may think the evidence isn't sufficient to convict your client on their own. But if your client is thrown into a single trial with multiple defendants, then it's sort of human nature that the jury is going to throw your client in with the others. And the evidence that's actually strictly relevant only to the co-conspirators and not to your client will also tarnish your client and make it more likely that your client will get convicted. So that's a reason defense lawyers don't like conspiracy charges, because they don't want their clients to be tried together with other people, again, who may be more clearly guilty or more culpable within the conspiracy. But prosecutors love it for the opposite reason. It makes it easier for them to convict people even when the evidence against them is a little bit thin. And by the way, for those of you who will be future prosecutors, this is a real ethical dilemma that not all prosecutors take as seriously as they should. If you have thin evidence against a given purported member of a conspiracy, then of course you're going to be tempted to want to throw them in with everybody else and convict them. And maybe you can do so, but you should at least consider the possibility that your evidence is thin because maybe this defendant wasn't really part of the conspiracy, right? And you don't, above all, as a prosecutor, you do not want to convict innocent people. And unfortunately, we all tend to have biases based on, in part, the jobs that we're performing. Prosecutors, and I say this as a former federal prosecutor myself, prosecutors have a bias towards suspecting people of being guilty, even when the evidence is relatively thin, especially if they're associating with people that the prosecutor knows to be guilty. And that bias can lead to poor judgment. So think about it when you're a prosecutor. Think about the dangers that come from prosecuting people based on thin evidence. But the conspiracy statute allows that. Now, there is a more legitimate reason why prosecutors want defendants tried together, and that is that it simply saves resources, right? So if you have 8 different people who are involved in committing a single crime, it would be very difficult and take a lot of resources to have to try 8 separate cases. But if you can bring them all together in a single case with a single trial, it's much easier and cheaper. Number 3, a third tactical reason that prosecutors like conspiracy charges is that it allows them to get certain out-of-court statements into evidence, right? So if you've taken evidence, and by the way, if you haven't taken evidence yet, you really should. It's essential to the practice of law, even if you're not a litigator. Generally speaking, under the rules of evidence, out-of-court statements, that is, statements that are made not under oath in court, but somewhere out there in the real world, are not admissible at trial for the truth of the matter asserted. Okay, this is the hearsay provisions of the federal rules. You normally cannot introduce hearsay evidence at trial, largely because when you do that, there's no opportunity to cross-examine the person, the witness who provides the evidence, or at least who made the statement, right? But there are several exceptions to that rule against hearsay. And one of the big ones is for co-conspirator statements. If a member of a conspiracy makes a statement during and in furtherance of the conspiracy, then that statement can later be introduced into court as evidence. And the federal rules consider that to be non-hearsay. So if you're a prosecutor and you've got these out-of-court statements made by members of the conspiracy and they're incriminating, you're going to want to include them in your evidence at trial. And one of the best ways to do that is through this co-conspirator exception. Now, you can use the co-conspirator exception even if you don't charge conspiracy. That is, you can try and demonstrate to the judge that, in fact, this was a conspiracy and therefore the statement should come in, even if you're not charging a conspiracy. But as a practical matter, judges are much more sympathetic to claims that statements fall within the co-conspirator exception to the hearsay rule if you've actually charged conspiracy, right? You're putting your money where your mouth is. You are charging it. Presumably, in the federal system, you have to indict someone on conspiracy charges, which means that a grand jury has found probable cause to believe that the conspiracy exists, and so for that reason, the judge is much more likely to let the statement into evidence. So that's another tactical reason that prosecutors bring conspiracy charges. There's also a couple of others that are important. One is the conspiracy charge allows them to use something that's known as a speaking indictment. A speaking indictment. So normally, an indictment is a formal charge that a person has committed a crime, and it's issued by a grand jury. So the prosecutor writes it up, but then the grand jury votes on it, and if they decide that there's probable cause to believe that the person has committed a crime, then the indictment issues, right? And normally the charges in an indictment, each charge is a separate count of the indictment. That's how they're structured. So count 1, mail fraud. Count 2, wire fraud, whatever it is, right? There'll be different counts for each crime. But normally the counts have to be relatively short and to the point. They just sort of state what the alleged crime is and give a very brief factual background as to the crime. It doesn't allow the prosecution to really tell a story about the overall picture that they think exists concerning the crimes committed by the various members of the conspiracy. But if you have a conspiracy count allows the prosecutors to actually write a very long, if necessary, a very long narrative laying out the nature of the conspiracy, the scope of the conspiracy, the purposes of the conspiracy, background, how it came together, who's involved, what each person's role was, etc. And this is valuable in part because it gives a good roadmap for the case, so that everyone kind of understands what's at issue. But also, even more importantly, the indictment, after the case is over, after the parties have made their closing arguments and the case goes to the jury for deliberation, one of the things the jury gets in the jury room is a copy of the indictment, right? So if the jury in a big complex case is trying to figure out whether in fact these crimes were committed or not, it'll have this indictment to look at. And if you've got a conspiracy count which reads like a novel, and the jury is able to read through it and understand what the government's claims were, the jury's more likely to convict in big complex cases like that. So again, it gives a big advantage to the prosecution. And then finally, one last tactical benefit that prosecutors get from conspiracy charges, it has to do with venue. So where, in which venue can the case appropriately be brought? Which federal district can be home to a prosecution. And this is an important issue because remember, the U.S. Constitution gives defendants the right to a trial by jury in the vicinity of the offense, that is, in the local area, in the state and district where the offense was committed, right? So the Constitution says we can't take you away from your home and try you in front of a jury 1,000 miles away, which has nothing to do with where the crime was committed. It has to be done locally, right? It's one of the provisions in the Constitution that was supposed to protect against government tyranny, right? If you think about it, during the Revolutionary War, one of the things the British tried to do in the run-up to the Revolutionary War was to take American colonists who were committing various crimes in protest of British taxes. They tried to take those colonists to England for trial because American juries were acquitting them. And the Americans thought that was an abuse. You can't take me away from the local jury, the local community where the crime was supposedly committed. And so that's now in the Constitution. The trial has to be done in the place where the crime was committed. Well, if you have a conspiracy charge, and let's say the conspiracy involves overt acts that occurred in a wide variety of places, right? Maybe the defendants traveled and communicated with each other from different locations throughout the conspiracy. Guess what? Any location where an overt act occurred in furtherance of the conspiracy is proper venue for a conspiracy charge. So that means that the government now actually can choose where to try the case. It can choose to take you 1,000 miles away from where the main part of the crime was committed, so long as some part of the conspiracy took place there. Okay, so again, it gives the federal government enormous flexibility in deciding where to bring these white-collar cases, right? So again, notice one of the themes of this course I hope you're aware of, and that I hope you sort of maintain awareness of, is how very much power the federal government has in bringing criminal charges in the corporate context, right? We talked for several days about how easy it is to establish criminal liability for the corporation based on respondeat superior, how easy it is to make individual members of the corporation criminally responsible for the acts of their subordinates. And now you're seeing also how the use of something like a conspiracy charge can give the federal government lots of tactical advantages that make it much more likely that defendants will be convicted. Okay, and so it's not a mistake. If you look at the statistics, something like 95 to 97% of all federal cases result in plea bargaining rather than trial. That is, the defendant pleads guilty in exchange for some sentencing benefit rather than going to trial in 95 to 97% of all cases. And that's precisely because the federal government has so much power, both doctrinally, because of these the rules about corporate liability and vicarious liability, but also tactically through the use of things like conspiracy charges that give prosecutors a big leg up. Okay, now let's talk about some actual doctrine here. So let's first start by looking at the conspiracy statute, 18 U.S.C. section 371, and I'm just going to read it to you real quick. If two or more persons conspire either to commit an offense against the United States or to defraud the United States or any agency thereof in any manner or for any purpose, and one or more of such persons do any act to affect the object of the conspiracy, each shall be fined under this title or imprisoned not more than 5 years or both. If, however, the offense, the commission of which is the object of the conspiracy, is a misdemeanor only, the punishment for such conspiracy shall not exceed the maximum punishment provided for such misdemeanor. Okay, so that last part just has to do with the appropriate sentence for a given crime. But let's focus on the elements of conspiracy itself. So just looking at the statute again, and you can sort of hopefully take notes, you can break this down into elements. So first you need two or more persons, right? That's, I guess, fairly obvious. One person can't, although I often try to conspire with myself, I'm not successful because I'm only one person, despite my multiple personalities, right? You need two or more persons, okay? And they must conspire. They must conspire. What does that mean? It means they must reach an agreement about something. They must reach an agreement about something. And by the way, an agreement, as we will see a little bit later on, means, number one, an intent to agree. That is, both parties have to intend to enter into an agreement. And number two, there has to be an actual meeting of the minds. They have to actually agree about the about furthering some criminal end. Okay, so you need two or more persons. They must conspire, that is, enter into an agreement. They have to have the intent to agree, and there has to be an actual meeting of the minds. And then what's the object of the conspiracy? What must they conspire to do? Well, there's two alternatives in Section 371, right? They must either conspire to commit any offense against the United States, right? So they conspire to violate federal law. That's one kind of federal conspiracy. Or they conspire to defraud the United States or any agency thereof. Okay, so either to violate federal law or to defraud the United States. And as we'll see, this second prong, this defraud prong, it actually is different than what you would think. Normally, when you want to defraud someone, it means you're trying to trick them out of money or property. But the definition the courts have given defraud under Section 371 is a little bit different. And basically, I'll say it now, and then we'll come back to it later. To defraud the United States under this statute is to impede or obstruct the lawful functions of the federal government or a federal agency. Again, to impede or obstruct the lawful functions of the federal government or of any agency. Okay, so that's, and by the way, you can also defraud the federal government by trying to trick it out of money, right? The word defraud includes that definition, but it's broader than that. It also includes any scheme to impede or obstruct the lawful function of the federal government or any agency thereof. Okay, and we'll see in a little bit why that's important. Okay, so that's Section 371 in a nutshell. We need two or more persons. They have to agree with each other, either to violate federal law, federal criminal law, that is, or to defraud the United States. Okay, now let's start looking at our cases. And first, the first sort of theme of our first couple of cases is what's known as the plurality requirement. The plurality requirement, remember when we looked at the statute a second ago, it talked about two or more persons, right? So under federal law, to have a conspiracy, you have to have two or more people who actually agree to commit a crime. Now, I want to take note, and I hope you know this already from your first year criminal law class. This plurality requirement is not required in every state. The state law varies on this issue. And the reason for that is that the Model Penal Code, which was first promulgated in the 1950s, actually allows unilateral conspiracies. The Model Penal Code allows unilateral conspiracies, and some states have adopted that part of the Model Penal Code. What is a unilateral conspiracy? Well, that's where I am conspiring to commit some crime, but the person with whom I'm conspiring is actually a police officer or an informant, right? So I conspire with someone to, I don't know, sell drugs, right? And I say, hey, let's sell drugs together. And they say, great, let's do it. I'll meet you on the corner tomorrow. I am guilty under the Model Penal Code of conspiracy to sell narcotics, even if the person who says, yeah, let's do it, is actually an undercover police officer, because I have the requisite intent to conspire and the requisite actus reus, etc., and so forth, right? So that's one possible approach to conspiracy, and some states follow that approach. So when you're practicing law in a given state, if conspiracy comes up, make sure you understand whether your state is a unilateral conspiracy jurisdiction or a sort of plurality jurisdiction. But the federal government is a plurality jurisdiction. The federal government follows the traditional common law rule that you actually have to have a meeting of the minds between two people in order to have a conspiracy. Okay, so let's look at some cases that help us understand what that means. The first case is United States versus Stevens, a case out of the 11th Circuit. And this is a case where the defendant was a contractor who had some contracts to do work for the federal government, and he owned several corporations that were designed to assist him with his work, but in fact he used these corporations to defraud the federal government. And so the federal government ended up charging him with the violation of 18 U.S.C. section 371, claiming that he had conspired with these corporations to defraud the government, right? So a conspiracy between Stevens and his wholly owned corporations. And the government's theory of the case was as follows. They basically said, look, the courts have previously said that a corporation can conspire to violate federal law. That is, that a corporation can be a defendant in a federal conspiracy case. And moreover, and we're going to talk about this a little bit more in more detail when we talk about the McAndrew versus Lockheed Martin Corporation in a second. The court has also said that a corporation can conspire with its own employees to violate federal law, right? And so the theory of the case here was, well, you have 4 different corporations and you have 1 human being, and all these corporations are conspiring with the human being to violate the law, and therefore we have a conspiracy. But the 11th Circuit rejects this argument. The 11th Circuit says, no, 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 no. In this case, you can't convict Stevens of conspiring with his corporations. Why? Well, because there's apparently no other human beings involved in this particular conspiracy. All the corporations are wholly owned and wholly controlled by Stevens. There appear to be no other human beings involved in this attempt to defraud the federal government, right? And so the court says a case like this doesn't involve any of the dangers that that conspiracies give rise to and that justify conspiracy liability. And so the court in McAndrew talks about this a little bit. Why do we allow prosecutions for conspiracy in the first place, right? And if you think about it, it's kind of an interesting question, because a conspiracy is completed as soon as 2 or more people agree to commit a crime, and under federal law, one of them commits an overt act in furtherance of the conspiracy. But the overt act can be almost anything. So if I make a phone call to my co-conspirator to talk strategy, then that is an overt act in furtherance of the conspiracy. It can be the smallest little act whatsoever. And so you may ask yourself, well, why would we allow people to be prosecuted for conspiracy when they haven't actually committed the underlying crime? And in fact, they may not even be close to committing the underlying crime. Maybe they never will commit the underlying crime, right? There's plenty of cases where people in the heat of passion or perhaps under the influence of alcohol or whatever agree to do things that in the light of day and upon cooler reflection they won't ever follow through with, right? So when we allow people to be convicted for conspiracy, we're allowing people to be convicted who may never have actually completed the crime or even really tried to complete the crime. So why do we allow this? Why do we allow conspiracy liability at all? And rather than just requiring the crime to be committed or at least attempted before criminal charges can be brought? Well, the answer to that is that it is thought that conspiracies are generally more dangerous than in decisions by individuals to commit crimes. And there's several reasons for this. Number one, once people agree together to commit a crime, it's thought that they are less likely to back out. Okay, there's sort of peer pressure or groupthink or whatever, that you're now under the influence of the group, and so you're more likely to follow through than you would be if you were just on your own deciding to commit a crime. It's also thought that people who conspire to commit a crime can often do a lot more harm because they can, by working together, accomplish more complicated and serious crimes than they could on their own. It's more likely that the group will commit a large number of crimes as a result of the conspiracy because, again, you're an ongoing operation, and so you likely are not going to stop at one crime. And hold on one moment. Okay, I was just checking to make sure I hadn't forgotten anything. Yeah, I think I've covered the waterfront. I mean, those are the basic reasons why conspiracy liability is permitted. Again, because of the thought that you're more likely to follow through on the crime. If you're part of a conspiracy, you're going to commit more crimes as part of the conspiracy. Crimes are likely to be more complex and involve more harm. There may be a greater number of crimes, as I just said, and it may go on for a longer period of time. And so we allow the government to charge conspiracy even where there's no underlying crime committed. But the court in Stevens says, none of those dangers are present when you have a conspiracy that is simply between a person and wholly owned corporations, right? Because it's not like Stevens is going to feel peer pressure from his wholly owned corporations to follow through with his criminal scheme, or that he'll engage in groupthink or anything like that, right? I mean, because they're just legal fictions, these corporations. They don't have any separate existence from Stevens except as sort of legally recognized entities that have some basis in law but no basis in reality when there's no other human beings involved. And so the court says, when you have a case like this where there's only one human being and the rest of the defendants are all wholly owned corporations, then there's no basis for a conspiracy charge because you have not met the plurality requirement. Okay, we need at least two human brains involved. Now, I want to take note, this doesn't mean that two human beings have to actually be charged with a conspiracy, right? So it would be enough that if there was some employee of one of Stevens corporations who was involved in the conspiracy to defraud the federal government, then it would be okay to charge Stevens with conspiracy, even if you only charged him with conspiring with the corporations and not with that individual himself or herself, because you would still have two minds that actually agreed, and it would just be that the prosecution, although they could have charged the employee of the other corporation, chose to exercise its discretion to just charge the corporation that person worked for based on respondeat superior liability. Okay, so again, bottom line, you need two human brains agreeing with each other in order to have conspiracy liability. But you don't have to charge both human beings with the conspiracy. In fact, you don't have to charge any of the human beings with a conspiracy. One could imagine a situation where an employee of one corporation conspires with an employee of another corporation to commit some crime, and the federal government simply charges both corporations with conspiring to commit the crime based on, once again, respondeat superior liability. And that would be fine, but at trial the government would have to prove that some human being, in fact, or that there was more than one human being, in fact, agreeing to the crime on behalf of their employers. Okay, so so that's the story with the Stevens case and the plurality requirement. Now let's talk about our second case in this section, McAndrew versus Lockheed Martin Corporation. So now this is a case, it may have been a little confusing when you read it because it's a civil case, but the court's analysis actually is an analysis of the criminal conspiracy doctrine. So just focus on that. What the court is talking about when it talks about conspiracy is the requirements to prove conspiracy under Section 371. And so this is a case where Lockheed Martin Corporation was getting investigated by the federal government for violating the Foreign Corrupt Practices Act in relation to the sale of some planes to Egypt. Now, the Foreign Corrupt Practices Act, as we'll discuss later this semester, is basically an act prohibiting U.S. individuals or corporations from bribing foreign officials, okay, in order to do business in foreign countries. And so the allegation apparently is that Lockheed Martin was bribing Egyptian officials in order to get these planes sold. And so the federal government was investigating that claim, and as part of the investigation, they subpoenaed McAndrew, who was an employee of Lockheed Martin who was involved in these sales. They subpoenaed him to testify before the grand jury. And it's McAndrew's allegation is that just before he was going to testify, he got a call from one of his superiors telling him not to testify. And he replied that I basically have to because I've been subpoenaed. And he then later heard that this individual, as well as several other members of senior management, had decided to fire him because of his decision to testify. And in fact, he did end up getting fired. And so the lawsuit is basically based on the notion that he's violated a whistleblower provision, that they initially conspired to prevent him from testifying in this FCPA case, the Foreign Corrupt Practices Act case, and that they then fired him in retaliation. And so the conspiracy part of it is a conspiracy under Section 371. And for our purposes, what's important here is the court's discussion of the intracorporate conspiracy doctrine. So when McAndrew tried to argue that various members of senior management, I think their names are Graham, Powell, Goldfarb, and Blackwell, and McClellan as well, that these guys had all conspired together to prevent him from testifying and to fire him in retaliation. Their defense was, look, we can't have conspired under federal law because we are all part of the same corporation, right? We're all part of the same corporation. And so for purposes of federal criminal law, we're actually all one individual. We can't conspire with each other because that would be essentially the corporation conspiring with itself to commit these crimes. And this is what's known as the intracorporate conspiracy doctrine. And so they say we couldn't have been guilty of conspiracy because we're all employees of the same corporation. Now, this defense, the intracorporate conspiracy doctrine, is a real defense under federal law. But as the court discusses in the McAndrew case, it is not a defense that applies to all conspiracy cases. It's actually a defense that really only applies in antitrust conspiracy cases. So remember, the Sherman Antitrust Act contains various provisions. One of those provisions makes it a federal crime to conspire to engage in restraint of trade, right? So the notion is if several people get together and try to interfere with the market by conspiring with each other and thus freeze out competitors or fix prices or whatever the case may be, then they're guilty of conspiring to restrain trade under the antitrust statute. The intracorporate conspiracy doctrine arose in the context of this statute because the federal prosecutors started charging various members of the same corporation as sort of conspiring to restrain trade, right? So you can imagine, for example, a given company decides, gets together and decides to set the price for a certain product that is going to sell on the market. And for whatever reason, the federal government thinks that there's something wrongful about the price that they set. The government tried to, in a number of cases, to charge those individuals with conspiring in restraint of trade. But the courts very sensibly said, no, 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 no. Conspiracy in restraint of trade means conspiracy between different companies, right? Where different companies within a market agree with each other to restrain trade by fixing prices or freezing out competitors or whatever the case may be. It makes no sense to talk about members of a single company conspiring to restrain trade, because that's basically just the company making economic decisions about its own business. It's not conspiring with anyone outside the corporation, right? So the intra-corporate conspiracy doctrine said that, at least in the antitrust context, you could not charge members of a single corporation with conspiring to restrain trade either with each other or with the corporation, right? Because they're all part of the same company. But the court says, that reasoning, although it makes sense in the antitrust context, really does not make sense in other contexts, that is, in the context of other types of criminal conspiracy, right? Because if you think about it, I mean, the reason that the court initially allowed corporate criminal response or criminal liability in the first place, as we discussed in our very first class, was to expand the scope of federal criminal liability so that you could hold entire corporations responsible for the wrongdoing committed by their employees. And so to sort of artificially say that you can't have a conspiracy involving a corporation and its own members, or just among members of a single corporation, would actually restrict conspiracy liability quite a bit, and thus make it harder to accomplish the purposes of conspiracy law, right? Remember what we said just a few minutes ago about why we have conspiracy liability in the first place. If you applied the intercorporate conspiracy doctrine across the board, and not just in antitrust cases, conspiracy doctrine itself would become much less powerful in the white-collar context, right? And so the court says, no, no, no. The intracorporate conspiracy doctrine only applies in a limited number of contexts, particularly antitrust, and there may be others as well, but it's a limited doctrine. But in general, members of a corporation can conspire with each other and with their employer to violate federal law or to defraud the federal government, and they can be charged under Section 371. Okay, now let's talk about our second major topic for the day, which is mens rea and the object offense. So mens rea, remember, is the intent requirement. Mens rea is a fancy Latin term. It actually literally means bloody mind, but it's basically the general rule that a person has to have some kind of blameworthy state of mind before they can be convicted of an offense. And so the question is, what is the mens rea requirement for conspiracies? So let's talk about that first in terms of this case, United States versus Grieco. And this is a case, by the way, reading this case, I'm not familiar with this case independently, but boy, it looks like a mob case to me. I could almost imagine, a scheme like this being set up on The Sopranos. You've got these defendants who come up with a scheme to skim money from a parking lot business. And it's a fairly elaborate scheme where they have false time cards so that, someone who goes and parks their car for a long period of time at the parking lot will go to the attendance station and will pay for that long period of time. But then the attendant will switch that card out with a card indicating there was only a short period of parking. and they'll skim the difference between the money owed for a short parking period and the money actually paid for the longer parking period. And the scheme apparently generated just tons of money for the defendants. They were swimming in it. They had to figure out what to do with it. They were keeping it in safes in their houses, and they were buying real estate with cash, right? So fairly big scheme, it appears, in this case. And that's, again, why I think mob. It's clever. It's hard to detect, and generates lots of cash. But again, I could be wrong. They could just be individuals with an entrepreneurial spirit who don't mind committing crimes. So anyway, they're charged with a variety of offenses ultimately once the scheme is uncovered. But one of those offenses is conspiracy, a violation of 18 U.S.C. Section 371. And in particular, they're charged with conspiracy to defraud the IRS by impeding its operations. Conspiracy to defraud the IRS by impeding its operations. And the issue in this case is whether the defendants have the requisite mens rea for a, quote, Klein conspiracy. And a Klein conspiracy is simply, that's based on the case where this doctrine arose, the Klein case. A Klein conspiracy is one of these conspiracies essentially to evade taxes, but to defraud the IRS by impeding its operations in the collection of taxes. And so the defendants try to argue that they don't have the right mens rea. So let's talk our way through this so we can figure out what it means. First of all, let's look again at the statute itself, because I want you to understand what type of a conspiracy is being charged here. So remember, as we discussed earlier, there are two types of conspiracy under Section 371. One is a conspiracy to commit an offense against the United States. That is, a conspiracy to violate federal criminal law of some kind. But then there's a second type of conspiracy, which is this conspiracy to defraud the United States or any agency thereof. And so the defendants in this case are charged with the second type of conspiracy, the conspiracy to defraud the United States by impeding or obstructing the functions of the IRS. Okay. And so what's the issue in this case? Well, let's look briefly at our elements of the offense so we can understand what the government's theory is and why there might be an issue. So to prove a Klein conspiracy, you have to show, and again, this is basically the same elements we see in all conspiracies, but I'm just kind of breaking it down for you. First, there has to be an agreement to impede or obstruct the lawful function of the U.S. government, in this case by evading taxes, right? And that agreement has two subparts, right? Number one, each defendant in the conspiracy charge must have the intent to agree. And then number two, there must be an actual meeting of the minds, okay? So you have to have that agreement, which is the intent to agree, and the meeting of the minds. And then number two, there has to be an overt act by at least one of the conspirators in furtherance of the conspiracy. Now, in this case, there's no question about the overt act because they all did actively evade taxes, right? There were lots of overt acts here. They failed to file, they failed to report all this income. They were, remember, they're keeping it in safes. They're buying cash, or property with cash. They're structuring things so that the IRS is less likely to become aware of them. So all the defendants clearly, in fact, evaded taxes. So they definitely had the overt act requirement met. The issue here is whether they had an intent to conspire to evade taxes. And the reason this is an issue in a case like this is because if I receive illegal income, then I have a powerful incentive to evade taxes, right? I don't want to pay taxes on it. Plus, I may be worried that if I report the income, then the government may start investigating me and discover my crime, right? So I've got both a financial incentive and a sort of criminal interest incentive not to report my income. And it may be the case that every individual member of the conspiracy does exactly the same thing. They all fail to report their income because all of them want to keep the extra money and all of them don't want the government to become aware of their crime. But the mere fact that all of them have done the same thing, they've all acted in parallel, does not mean that they've actually agreed with each other to do this, right? It does not mean that they've actually reached an agreement together to evade taxes, right? So the defense in this case, in the Grieco case, was, look, yeah, we all evaded taxes, but there's no evidence that we conspired to do so. That's what they try to argue in this case. But the court doesn't buy it. The court does not buy it. First of all, the court notes that that the parallel conduct, although it's not in and of itself enough to prove conspiracy, is definitely relevant to whether there was a conspiracy, especially in a case like this. Because remember, if I'm involved in a conspiracy like this, I have an interest not only in not reporting my own income, but also I have an interest in making sure my co-conspirators don't report. Because if one of them reports their income, then again, that might trigger a federal investigation that leads right back to me, right? So there's reason to believe that in a case like this, people might want to conspire with each other. Now, it doesn't mean they actually did, but it indicates that it's reasonable to suspect that that might happen, right? And then if they all act in precisely the same way, that makes it look a little bit more like maybe they conspired. Although, again, that's not quite enough to prove it. But finally, the court says there was some evidence here that they actually did conspire with each other. In particular, Grieco told various members of the conspiracy not to deposit their money in a bank, but instead to put it all in safes in their homes, and also that he advised them to purchase real estate using cash, and that he referred them all to the same agent, etc., who helped them structure the purchases in a way that was least likely to get attention from the federal government. And the court says this is enough. This is enough. Here we have them actually talking with each other about how they're going to hide their proceeds. And that, combined with the parallel conduct and combined with the incentive that they would have had to make such an agreement, is enough so that a rational jury could conclude beyond a reasonable doubt that in fact they did conspire with each other. Okay, so again, just wanted to highlight for you, there has to be an actual agreement, and not just in these tax evasion cases, but in any federal conspiracy case, an actual agreement to commit the underlying crime before you can be convicted of conspiracy. Okay, so that's super duper important in these conspiracy cases. Parallel conduct in and of itself is generally not enough to prove the existence of the agreement, although it is relevant to the question of whether there was an agreement. Final point about this, I want you to note there's no explicit evidence of agreement in this case, right? There's no sort of smoking gun moment where we have evidence that they all got together and said, let's evade taxes, right? There's no overt mention of tax evasion that's presented in evidence. But that's okay, because it's rare that you're going to have that sort of direct evidence of conspiracy, where you have people making statements, let us conspire to defraud the federal government, right? That's not normally going to happen. And if it does happen, you often won't have direct evidence of it because the conspirators will choose not to testify at trial. But you can convict based on circumstantial evidence, so long as the circumstantial evidence is strong enough so that a rational jury could find beyond a reasonable doubt that the agreement must have existed, given the various ways that the members of the conspiracy acted in the case. Okay, now let's look at our next case and our final case for the day, United States versus Licciardi. So this is a case where there were some grape wholesalers who conspired to pass off cheaper grapes for more expensive ones during the Zinfandel craze of the 1980s. You probably weren't aware of the Zinfandel craze. I'm aware of it because I was, just sort of reached the age where I could drink during that era, and I had to endure white Zinfandel, which is a very sweet kind of wine. Maybe you like it. I don't mean to insult your taste in wine, but boy, I sure didn't. But anyway, in the 80s, Zinfandel became a big deal, and the price of Zinfandel grapes skyrocketed from like $100 per ton to $1,000 per ton or something like that. They went up a huge amount, which of course created incentives for people to pass off cheaper non-Zinfandel grapes as Zinfandel grapes so that they could pocket the difference. And that's in fact exactly what the wholesalers in this case apparently did. They sold the cheap grapes to the winery, claiming that they were the expensive Zinfandel grapes, and they got paid a premium for the grapes, even though in fact they themselves didn't have to pay very much to buy them from the growers because they were cheap grapes. All right, so the government charges them again with conspiracy in violation of 18 U.S.C. Section 371. And once again, we have an issue concerning mens rea. And we're going to talk about that in a second. But what I want you to understand is how this case gets resolved, because the wording of the opinion is a little bit unclear in places. And so I want to just kind of highlight for you what was really at stake, what was really at issue in this case, and how the court really resolved it. And the hint I'm going to give you right now is that we have what's often called a multiple object conspiracy, which is something that is permitted under federal law and that again enhances federal power. And so let's look at the statute again, and then we're going to talk about what the court said in the Licciardi case. So remember, as we've said a couple times now, that there's two different ways that one can violate Section 371 in broad terms. You can conspire to commit an offense against the United States, or you can conspire to defraud the United States. And here, what's at issue is the defendants were charged with a conspiracy that had multiple objects. They were charged with a single conspiracy that had multiple objects. And so the indictment against the defendants said that they conspired to defraud the Bureau of Alcohol, Tobacco, and Firearms by obstructing it in its lawful function, and they conspired to violate the mail fraud statute by defrauding the winery, right? By tricking the winery into paying more money for these cheap grapes than they were really worth. So you had this single conspiracy charge that basically charged two different objects: the purpose of defrauding the Bureau of Alcohol, Tobacco, and Firearms, and the purpose of violating the mail fraud statute by defrauding the winery. Okay, and so the defendants in this case try to sort of attack the indictment by saying, look, there's not enough evidence that we conspired to defraud the Bureau of Alcohol, Tobacco, and Firearms. So let's pause for a moment on this argument. Remember what we said about the word defraud under Section 371. You can defraud the federal government by obstructing or impeding its lawful functions, right? And so the argument here was that the defendants conspired to obstruct the lawful functions of the Bureau of Alcohol, Tobacco, and Firearms by causing the winery to file forms with the Bureau that contained false information. And since the forms contained false information, the Bureau was not able to do its job properly, and therefore its functions were impeded, and therefore the federal government was defrauded, right? So again, notice how strange this is in a way, right? Because here, although, in our last case, we talked about a Klein conspiracy where you're basically evading taxes. And it's easy to see how that's fraud, because there you're trying to take money from the federal government, or at least avoid paying money to the federal government that you actually owe. But here, it's not like the BATF is being defrauded of money. It's simply being deprived of its right to have forms that have accurate information on them. And that's enough to be fraud under Section 371. Okay, so it's important to understand that a conspiracy to deprive the BATF of its lawful function can be simply a conspiracy to file forms that have inaccurate information on them. But of course, the defendant's argument is, well, yeah, I guess we did cause the winery to file these forms, but it wasn't the object of the conspiracy. We actually didn't even really think about the BATF, and there's no evidence that we thought about the BATF. And so unless it was at least one of our purposes to defraud the BATF, you can't convict us of this sort of conspiracy. And the court says, you know what, you are absolutely correct. You are not guilty of conspiring to defraud the BATF, but unfortunately for you, the indictment says the same, and remember this is the same count of the indictment, says that you not only conspired to defraud BATF, but you also conspired to violate the mail fraud statute, because you conspired to use the mails in furtherance of a scheme to defraud this winery of its money or property. And you clearly did have the intent to do that. You clearly did agree that you were going to engage in mail fraud. And because you had the intent necessary to conspire to commit an offense against the United States, we are going to uphold your conviction. Okay, so now again, I want to just close out by saying, notice how much latitude this notion of a multiple object conspiracy gives to the federal government in indicting someone for conspiracy, right? Because you can charge them with a single conspiracy that has multiple objects. And indeed, it can have different types of object, right? It could be, some of its objects could be to violate various federal criminal laws, and it could have other objects that relate to impeding federal functions, right? And thus defrauding the U.S. And you can throw that all into a single count of the indictment, and if the jury buys any one of those theories, then the defendant is convicted, and the conviction will be upheld. Now, the one limitation on this is that if there are multiple objects alleged to the conspiracy, the jury has to agree unanimously about which object or objects were in fact proven. Okay, so there has to be unanimous agreement by the jury that, for example, the defendants conspired to commit mail fraud in order to uphold the conviction based on the mail fraud statute. Okay, so in theory, you cannot have a conviction upheld where some jurors think that they conspired to defraud the government, and other jurors think that they conspired to commit mail fraud, but there's not unanimity about either of those. There has to be unanimity, or else the conviction will be overturned. All right, thank you very much.